talking legal matters with our professional via Zoom in Sydney, John Sutton from John Sutton Associates. John, welcome back. We had a chance to talk about a thousand things in the opening interview. I want to talk about some bail matters. Police in New South Wales, for example, appear to be, is it afraid or malicious in their application of the law at the moment when it comes to offenders responsible for certain offences?
The answer to that is yes, in that I think both of the issues are real. When a lawyer is admitted, no matter what state or territory, they go to the Supreme Court. And for me, I was fortunate. I had Chief Justice Spiegelman. I've been to others where the presidents of the appeal courts or just senior judges do a welcoming speech to the profession. And the speech will say that those of you who go to practicing crime will be dealing with the, shall we say, the less nice people of the community. But what is at the essence of what you're doing is not the character of the person you're dealing with, but the application of the law. And it's the application of the law that I want to talk about that you've highlighted on in relation to how bail is dealt with. Now, when I'm dealing with someone on a traffic matter, a serious drink drive with a collision that might involve bail, that can often invoke one emotional response from a police officer. But if we're dealing with people who have committed offences like possession of child abuse material, now that's got to be now near the bottom of the rung of everyone's likes in society. Not everyone, because there are people who look at that stuff. But when you get someone like that, often the law will be, in relation to bail, thrown out of the window by the very police officers who are supposedly trained to give consideration to it. And what that does is to denigrate the rule of law more broadly across the base that we all have to live by. And it's a thin end of the wedge. And so when you get someone who has got child abuse material, and I'm thinking of one I'm dealing with at the moment, who's well into his 50s, who's never committed another offence. There's no suggestion of any problems in the home. He's never created any problems whatsoever. The areas of bail concerns, there are 4 of them, and if necessary, I'll take you through them. But if you just accept for me that he didn't satisfy any of the bail concerns, but the police officers had determined there was no way he was going to get bail. So what it does is it clogs the system by then having to make him go to court, where, of course, I make a bail application and he gets bail straight away. Now, whether that's maliciousness or whether it's a genuine belief, I've got my own views, but it's certainly, what I will tell you, is not an application of the law. Or I'm currently dealing with another matter at the moment where, and it's had a degree of publicity in New South Wales at least, so I can't mention details of it, but where a young child was killed following a motor vehicle incident. And again, the driver, a professional driver, had a medical episode. But because there was a death, I honestly believe that the police didn't want to be seen as the people granting bail, notwithstanding the law says effectively that he should have bail because of the whole factual matrix that existed. But because they didn't want to be seen as the people granting bail, so we get to court, and of course I get him bail straight away. And this leads, particularly in New South Wales, where we're at record levels of people in custody. Such decisions against people who don't have the wherewithal, financial or intellectual, to get a lawyer to argue bail for them means that the jails are literally bursting at the seams with people who are in there who probably, numbers of them, should be on bail. Because taking the decision to not take bail might be wise if you're in a matter where a person is guaranteed a prison sentence and they're going to be pleading guilty. But where they're entitled to bail, where prison isn't inevitable at the end of it, they shouldn't be there.
So, okay,
and that's the issue.
So I understand the police would be fearful of some of the optics. But take us through, what are the 4 conditions for bail? What are the things that we always should understand? If bail is not given, it's not given because of 1, 2, 3, 4.
Well, to answer that, this is obviously, this is a New South Wales centric issue answer. But in principle, other states and territories have the same guidelines. So we have what's called bail concern. So if there is a concern, then the magistrate has to consider, or the officer has to consider, whether conditions can ameliorate the concern. So the first concern is fail to appear. Will the person fail to appear at court for any process or any finalisation of the matter?
So are they likely to abscond? Is that what you're saying?
Abscond or simply not turn up.
Right, okay.
Just they don't go. So that's the first one. Will they fail to appear? The second one is are they likely to commit a serious offence whilst on bail? And in the incidents that I've just outlined of the motor vehicle incident and the child abuse material, these people are in their 40s and 50s and have never committed any other offences at all. So that's highly unlikely. The second one is, are they likely to endanger the safety of the victims or witnesses? Well, no, again, for pretty obvious reasons, particularly with those two examples I've given.
So that third concern really is interference. Are they likely to affect the investigation? Is that right?
Well, that's the fourth one, funny enough. Now, are they likely to go and interfere with witness, so stand over them, threat them, cause them problem? Or are they likely to somehow affect the safety of a victim? So, for instance, domestic violence is the obvious one.
Yes.
Do you give the husband bail if there's clear evidence that he's inflicted violence once on the wife? So the obvious answer to that is, if he is going to get bail, the amelioration is to bail him such that he can't return to that address, as an example. And then the fourth one is, are they likely to interfere with evidence? So is there evidence still out there? Has the bank robber buried a bag of cash somewhere? Are they likely to go and dig it up? And so that's probably not a great example, but it provides a very basic example of what I'm talking about. And then in the New South Wales Act, there are Section 18 has 20 odd different specific considerations of what can be considered, what needs to be fitted under those four main headings, and then what conditions can be sorted or applied. And could be curfews, could be reporting to the police once, twice a day, could be living at a particular address, could be surrendering passports, could be making friends or family deposit amounts of money. But these are pretty basic and simple conditions or questions to ask. And what I'm seeing of late, and I know I'm not alone because I sit on a committee, I'll just say that, and it's a regular discussion about why is it that police so obviously should grant bail, but they don't, and they make you take the matter to court.
John, they don't live in a vacuum, the police. There must be instructions from above. And who would be directing them? Would it be their police command?
Well, I can say, in all honesty, without naming names, and I won't, that I've had conversations with informant officers who have said, look, John, we know these people should be getting bail, but it's a particular type of offence, and the boss has said there's no way we're being seen to be giving them bail.
So how do we change it? How do we see changes? How do we bring reform into this area?
Well, I recently made a submission that there needs to be better training, but quite frankly, these issues are often, well, they're always subjective because it's someone's opinion of what the situation might be, and it's someone's subjective opinion in a future sense of considering what the defendant might do in the future. So one but uneconomic but sensible resolution would be to have a non-sworn officer or an independent person be the person who makes the judgment on bail, because quite frankly, police have demonstrated time and again that they will be biased because either it's an unsavoury crime and so they don't want that person to get bail because they're dealing with what they view as someone at the lowest ebb of society, or they don't want their tail being held responsible for giving that person, to use your term, for the optics to be seen that they're going to give that person bail, and what's the publicity going to be around that area.
John Sutton, as always, whenever we ask you to help us through this legalese, You've had a fantastic capacity to break it down and enunciate for all of us the very complicated steps that we must follow and we try and follow. And it's always interesting to hear a perspective that tells us that even the police, in their efforts to do what they need to do, sometimes irk or choose to take the easy path rather than do what they're supposed to do, and that's follow through on their responsibilities. John Sutton, we will have much more to talk about, I dare say, because we're right in the middle of a very complicated COVID pandemic, which is throwing up new challenges, not only to the judicial community, not only to our police, but also to every politician that aspires to follow their constituents.
Well, it's been my pleasure, and it's always enjoyable talking with you, George, and I appreciate the freedom you allow me to express my opinions.
Thank you, John.